number 45, Batavia Townhouses versus the Council of Churches. Council?
Good afternoon, Your Honor. I'm Bill Bruckner with Woods Oviatt Gilman in Rochester, New York, and I'm here this afternoon on behalf of Council of Churches Housing Development Fund Company, Incorporated. I'd like to ask the court for the ability to reserve 2 minutes for rebuttal, please.
You may have 2 minutes, sir.
Thank you, Your Honor.
You're
May
welcome.
it please the court. In the 60 years since General Obligations Law 17105 was enacted, the courts of the state of New York have continued to properly analyze the reaffirmation of debt secured by a mortgage under both the General Obligations Law 17105 and under General Obligations Law 17101.
Does that depend on whether you're suing on the note or suing to foreclose?
Your Honor, it depends on whether the nature of the action is to foreclose a mortgage or to recover real property. We see those phrases used both in 17105-1, which is the provision that provides several mechanisms by which the statute of limitations can be extended in that action. And we know from the supporting language in 17101 that 17101 is applicable in all instances except for the recovery of real property. So yes, Your Honor, it depends on what the nature of the action is.
And what was the nature of the action here?
This action is an action to determine the enforceability of a note and mortgage. And it's important for the court to understand that, as we've seen through the Legislative Revision Committee, the critical distinction is that a note is a promise to repay, and a mortgage is the grant of an interest in real property.
In your briefs below, I believe it's with respect to, it says, this declaratory action is the limited partner's effort to invalidate the wraparound note and mortgage and to secure the partnership's ownership of the village free and clear. Doesn't that indicate we're talking about the mortgage and freeing the property?
It does, Your Honor, but there are two separate aspects of what the action is attempting to achieve. The first is attempting to obtain the property free and clear, and the second is to also invalidate the note, the underlying note. And so what's critical here...
Well, you also have a counterclaim, right?
I do not have a counterclaim. We merely asserted affirmative defenses, and the case is in the posture of mutual motions for cross motions for summary judgment.
So you didn't ask for a declaration?
I did not ask
Okay.
for a declaration, no.
Forgive the basic question here, but is this note a recourse loan? I mean, can you sue on the note independently of the mortgage, or is the mortgage the only recourse in terms of paying the debt?
It's a non-recourse loan to the extent that it makes the partners in the partnership it exculpates the partners in the partnership, but it remains a liability of the maker of the note
I
itself.
guess as a practical effect, what does that mean? I mean, can you go after anything other than the property
Well,
to satisfy the debt?
the property is the primary asset of the partnership, but
Right.
we would be able to bring an action on the note, breach of contract claim, and then use whatever assets were available to satisfy that obligation.
So to the extent the partnership had a bank account somewhere, the non-recourse element wouldn't prevent you from getting that?
That's correct. Clearly here, the financial statements that were provided to the Council of Churches, the creditor, on an annual basis between 2012 and 2019, satisfied all of the elements of a written acknowledgement under 17101. They were in writing. They contained nothing inconsistent with the intent to repay.
Were they signed, Counselor?
They were not signed, but they don't have to be, Your Honor. Under the compelling precedents across the state, we analyze the intent to reaffirm debt using ordinary business understandings and rules of common sense. And what we had here was a transmittal letter signed by the auditor of the partnership and transmitting the financial statements that referred to a note and mortgage payable in the ever-increasing amount of the obligation.
But this is an auditor who's independent, and you're saying that satisfies the requirement of conveying to the person who you owe the debt?
Again, Your
That
Honor,
it's sufficient?
we analyze the totality of the circumstances using ordinary business understandings and rules of common sense.
So
And though the
anybody
auditor
who
may-
files any independent document, some financial forecast, they send it over to an accountant, they send it over as part of partnership paperwork without an acknowledgement, without a signature, your position is that that would toll the statute of limitations indefinitely?
It would toll the statute of limitations each time that reaffirmation is sent, Your Honor, transmitted, because under all of the circumstances, we can imply the debtor's intent to repay.
That's actually what I want to ask about, which is that it seems to me that's the crucial question, right? Does it evidence some intent of the debtor to repay? And the financial statements have to be accurate, they have to meet, general accounting principles, right? And that debt is a valid debt that has to be reflected in those statements until the statute of limitations runs. So I'm not sure that I can infer anything other than an attempt to comply with accounting rules by listing those.
Your Honor, if this obligor didn't intend to repay, it would have instructed its auditors as of March the 2nd, 2018, 6 years after the last payment on the other obligation, that there had been an expiration of the statute of limitations and it no longer had an obligation to repay. So the
we
fact that
should
it was
be-
carried for another 7 years beyond that is what we believe indicates this obligor's intention to repay.
Well, they still have the obligation until the statute runs, right? So what you'd really be looking for is a financial statement that showed that obligation after the expiration of the limitations period.
The statute of limitations, 6 years from the last payment, Your Honor, would be March 2nd, 2018. And 2018 was the expiration of the statute of limitations.
Right.
There were financial statements that were provided from 2012 all the way through 2019, and I understand that they continue to this day.
Right, and so in the record, the one we have that is after the limitations period is the 2019 one.
That's correct.
Okay.
That's correct. So the acknowledgements meet all of the elements of the acknowledgement under 17101. We have an implied promise to repay the monetary obligation. The non-recourse element of the underlying note exculpates the partners in the limited partnership, but not the partnership itself. And it's our contention that there continues to be a monetary obligation that can be enforced by this court.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
May it please the court.
What type of action has been litigated throughout?
It's under RPAPL 1505, Your Honor.
And if it's under the RPAL, does 101 have any place, any applicability?
Your Honor, our position is that it does not. Nothing where you're dealing with a mortgage note, it's governed by 17-105.
What if you sued on the note only?
Still governed by 17-105, Your Honor,
And-
because it's a mortgage
And
note.
can you point me to somewhere in the complaint where you mention the real property law?
In the complaint, Your Honor,
Yep.
and not off the top of my head, but the action proceeded that way and has been treated that way and is referenced that way in the decisions of the courts.
So you pleaded it, do you know how you pleaded, or you're not sure?
I think it was pleaded as an action for declaratory judgment, Your Honor,
With reference to the RPAPL or no?
with reference to the enforceability of the mortgage note, Your Honor.
So I'm sorry, I'm on the screen, counsel. Good afternoon. On the screen? Hi. So I just want to be clear with respect to this last response. You're saying that the complaint sought a declaration that the note was enforceable?
Well, it was unenforceable, Your Honor.
I'm sorry, but the reference was to the note, that the note was unenforceable.
The mortgage and the note, it's referred to as a wraparound.
Yes,
mortgage and note.
yes, unenforceable on the grounds of the statute of limitations that expired.
That's correct, Your Honor.
Thank you.
So even if this case were governed by 17101, which it's not, we'd still prevail. Indeed, the Supreme Court ruled that we prevailed even under 17101. But this case is governed by 17105. That is the result that is dictated by the clear statutory language and by the explicit legislative history of 17105. Indeed, the whole purpose of the legislature enacting 17105 in 1961 was to establish a bright line rule with respect to mortgage notes. And under the language of 17105, it governs the tolling or revival of any mortgage and note, regardless of the nature of the court action. And under 17105, nothing less than an express written promise to pay suffices to revive a mortgage.
Counsel, I'm sorry to interrupt you, I'm on the screen. Can you respond to your adversary's point with respect to that back and forth with the bench regarding the non-recourse aspects of the note, with this argument that it's the partnership that remains liable, and so any of the partnership's assets would be subject
We
to
don't agree with
collection?
that, Your Honor. It's a
Okay.
non-recourse note. It's a real estate deal that's dependent on the real estate. And it was.
Yeah, but what's the non-recourse part? He's arguing, as I understand it, I could be wrong, you'll correct me, he'll correct me, that the non-recourse part is that it cannot go against the individuals, but it is the partnership that stays on the hook, right? What he says, the partnership is not exculpated. And if that's true, then all of the assets are available. Isn't that correct?
Well, if that were the result, Your Honor, then that would render 17105 a nullity.
How so?
Because if the mortgage note is unenforceable, then you can't enforce it either directly or indirectly.
Counsel, if I could ask, it might be the same question, just a different way. Is it your view that under this non-recourse note, that the only collateral, the only asset that can be recovered, used to satisfy the obligation is the property, or could there be more than that?
It's the sole asset of the partnership, Your Honor.
Well, the partnership does have some money in a bank account, right?
It does currently have some money in it.
So really, I think the question we're trying to get at is, if we look at the face of the note, is there something in there that says what the recourse is? That does it exculpate the limited partners, or does it exculpate the partnership?
Your Honor, I honestly can't answer that.
All right. We have the note, I think.
My apologies on that.
Could you turn to, just for hypothetically, if we were to conclude that 17101 applies, what would your argument be?
Well, our argument, Your Honor, is that neither the accounting statements nor the tax returns constitutes an acknowledgement of the debt. The Supreme Court so held with respect to the accounting statements. It didn't address the tax returns, but I think the result is self-evident. You know, that under the theory that's been advanced, anytime a partnership files a federal income tax return, it would be acknowledging debts simply by filling that out, and that it cannot be the case.
Do you perceive a difference between an acknowledgement that a debt exists during the period of time it can be collected because the statute hasn't run, and an acknowledgement that happens after the statute's run?
No, Your Honor, because first of all, the financial statements are required by the partnership agreement. The fact that there's a financial statement every year is a function of the partnership agreement. So it doesn't exist for
Right,
any
I guess,
other
let
reason.
me try it this way. Would you expect that the financial statement that issues after the debt is no longer able to be recovered because the statute of limitations has run, to no longer show that as a debt?
No, Your Honor, I don't, because from an accounting perspective, you want to show, the accountants will insist on showing stuff like that without making a legal determination about whether the debt is still enforceable.
Wouldn't they ordinarily at least include a note?
I'm sorry, Your Honor?
Wouldn't they ordinarily at least include a note towards the back?
Your Honor, in my experience, no. If they catch that, yes. But bear in mind here that the controlling entity, the entity that controls the partnership, that controls who's selected as the accountant, is in fact the same party that holds the mortgage.
Well, no, right?
It's the general partner.
But the- It's the
Constable's
general
both the general
partner, but it's
partner.
not, but there is a legal distinction between the partnership and the general partner. They're
Of course,
different entities.
I agree with that, Your Honor. But in practical terms, what's done with when you bring in your accountants is you flag for them issues. They may spot additional issues for themselves, but my point is that here, the general partner has no interest in flagging this issue.
And
for the
that is
accountant.
really sort of what is, not that particular issue, but the general issue of the breach of fiduciary duty is what has existed in the federal court that pre-existed this case, right?
Yes, Your Honor, there's a fundamental conflict here, and the various actions that would be said to acknowledge the note, particularly once the statute of limitations run, could be viewed as a breach of fiduciary duty at the same time, and therefore void ab initio. If there are no other questions, then I will submit. Thank you very much.
Thank you, counsel. Counsel, your rebuttal?
Your Honor, I think it's important to address this court's precedent in Petito versus Pafath. And there we had exactly the same action that we are facing in today's argument. It's an action to determine the enforceability of a note and mortgage. And this court in 1994 applied both 17101 and 17105 in determining whether those obligations had been, the statute of limitations had been extended with respect to those obligations.
Isn't Petito distinguishable, though? There was an intervening document, specifically the stipulation that resulted from the action, the enforcement action.
In fact, I don't think it's distinguishable. I think we have to engage in the same analysis, but come to a different result, Your Honor. And the reason that I say so, there had been an initial foreclosure which was resolved by a stipulation that called for a payment of less than the full amount of the outstanding balance on the note. And when the subsequent action to determine the enforceability of the mortgage and the note was brought, the plaintiff contended that that stipulation, agreeing to pay a lesser amount, was sufficient to toll the statute of limitations with respect to both the note and the mortgage obligation. This court concluded, applying both 17101 and 17105, that the fact that the amount was lesser than the full balance of the mortgage did not include an unmistakable intent to reaffirm that obligation.
Isn't
So the
there
writing
dis-
was inadequate. It wasn't that the analysis was
Isn't
different.
there a distinction with respect to Petito? The reviewing court, there was an acknowledgement under both that both sections applied, that 1701 and 17105, because in personam and the mortgage were both at play. But here, it's not, it's disputed.
That's right, it's disputed. What the underlying action attempts to do is to determine the enforceability of both the mortgage and the note, and the underlying obligation to pay.
But
And
in Petito, there was no non-recourse.
there was no non-recourse element. That's
So
correct.
both avenues were available.
That's correct.
But here, it's
Here, the non-recourse aspect of the note relates only to the individual partners, not to the maker of the note itself, the partnership. Thank you, Your Honor.
Thank you, counsel.